First up, we go to Lapeer, Michigan for a sentencing. 44-year-old Chadwick Mobley has pled no contest to first-degree murder and felony firearm. 14 years earlier, 20-year-old Andrea Alber was alone house-sitting for her aunt when Mobley entered the home, tied Andrea to a chair, and shot her once in the back of the head before leaving the scene. Andrea's boyfriend, 19-year-old Kenneth Grondin, was originally charged with and convicted of Andrea's murder. Grondin was sentenced to life in prison, but maintained his innocence. And 3 years later, that conviction was overturned after an appellate court found an issue with the verdict form. And 4 years after that, the case was reopened when advances in forensic testing helped investigators discover Mobley's DNA on a cigarette found at the crime scene. Mobley, now living in Utah, was arrested, charged, and pled no contest. Mobley didn't know Andrea. As for motive, he told investigators he was drunk the night of the murder. Today, Mobley appears before Judge Michael Nolan to hear his sentence. But first, members of Andrea's family deliver victim impact statements, starting with her stepsister, Carly Teachout, who faces the now convicted killer from just a few feet away.
To say that Andrea's murder was life-altering is an understatement. I was 17 years old when she was taken, when you shot her to death. You were a coward, Chad Mobley. Only a coward would shoot and kill a 20-year-old woman in the back of her head. You are not good enough to be considered a monster, because even a monster would have told us why, which is all we've ever asked for. Chad Mobley, this will be the last time I think about you, you complete waste of life.
Next to speak is the victim's aunt, Stephanie Hummer, whose house Andrea was watching the night she was murdered.
There is not enough time I could be given for me to explain the absolute hell of losing Andrea in my home, as it is truly life-shattering. My wish for you, Chadwick Mobley, is that Michigan had the death penalty, in which you could be led knowingly to a cold hard chair, strapping your body down and ending your life.
Before the judge imposes sentence, Mobley delivers a statement to the court.
Firstly, Your Honor, I would just like to say that I'm so sorry to the victims and their family. I got no words that could bring them solace, but I am so sorry for their loss. Thank you.
The final person to speak is Judge Nolan.
The question here is not whether a crime was committed, but why. What happens here today is not justice. How can the court possibly offer justice to this family when we can't even give them answers? It's not justice for Andrea Alber's family. It's been 4,901 days for this family with no answers. There's no justice being done today.
The judge sentenced Mobley to life in prison. He'll have no chance at parole. Next, we head to Ionia, Michigan for a plea hearing. 22-year-old Kaleb Hardy has been charged with assault of a prison employee and being a habitual offender. 5 months earlier, police say Hardy, who's already serving a 3 to 15-year sentence for robbery, got into an altercation with a prison employee and threw liquid at him. Today, Hardy appears remotely before Judge Ronald Schaefer to discuss next steps in the case. The state has offered Hardy what's called a Cobb's agreement, where the judge informs the defendant ahead of time what the sentence range would be if they were to plead guilty. In this case, that would be from 10 to 23 months to a maximum of 5 years in prison. If he turns down the offer and is found guilty of both charges, he's potentially facing an additional 6 years in prison and a $2,500 fine. Hardy's represented by Assistant Public Defender Larry Lewis.
Mr. Hardy, can you hear me okay? Yeah, I heard.
All right, talk to the judge, and he would cap at the middle of the guidelines. Would that be correct, Your Honor?
Correct.
So basically, 17 months?
Man, yeah, I'm gonna take the 17 months. That's the lowest you all can do. I'll take the 17.
So you want to take the offer?
Man, yeah, bro, yeah.
So do you want to waive your right to have a trial in order to take advantage of what was just placed right on the record?
You know, I don't want to take that 17 months.
It appears that Hardy has changed his mind.
Well, that's fine. If you don't want to do this, then you'll come back at a later date and time and you can take the next step in the case, but that doesn't mean the offer would still be open. You might have to plead to a habitual offender then, and then the guidelines are going to be much higher.
All right, come on, man. Come on. I'll take the 17 months, bro. Y'all making it more complicated than what it got to be, bro.
Back to the plea taking process then. So are you waiving your right to have a trial in order to take advantage of this offer that's been made this morning?
Man, yeah, bro.
All right. How do you plead to the charge of assault of a prison employee? How do you plead?
I plead guilty.
Can you tell me what you did to assault Officer Ball?
I didn't assault Officer Ball. What are you talking about?
Well, if you did assault anybody, then we don't have a plea. Mr. Lewis, you want to help me out?
Mr. Hardy, did you in fact throw some liquid on the officer?
Man, yeah, bro. Y'all.
I guess did you or did you not throw some liquid on the officer?
Man, y'all.
So is that a yes or a no? If it's no, that's fine. We're coming. We'll have a trial if you want to do that. If it's yes, then we can.
I just said it, yeah. I just said yeah. Man, move it on. I just said yeah.
So making incomprehensible noises doesn't mean it's yes. You did assault him. You did throw some liquid on the officer. Is that correct?
Man, yes.
All right.
Yes, move on.
Well, we got to have a definitive answer. Mr. Hardy, do you want the court to accept your plea to assault of a prison employee? I'm sorry, sir. I didn't catch that. Is that a yes?
I say yeah.
All right. I will accept your plea. Mr. Hardy, you are all set today. You are free to sign off.
A month later, Judge Schaefer sentenced Hardy to 16 months to 5 years in prison for the assault charge. It'll run consecutively to his original 3 to 15-year sentence. The habitual offender charge was dismissed.
Want to know why the judge originally said you had to be drug tested? Is because the only thing that you're fired up about in life is your marijuana.
We head to Gaylord, Michigan for a probation violation hearing. 31-year-old Dawn Crowe has pled guilty to retail fraud. A year earlier, Crowe was arrested for shoplifting an item from a sex shop. She pled guilty and was sentenced to 6 months probation with several conditions, including that she complete volunteer services through a county work camp, attend a retail fraud class, and undergo regular drug testing. But when she failed to comply with those conditions, she was ordered back to court. Today, she appears remotely before Judge Kevin Hesselink to find out if her probation will be revoked and if she'll be sent to jail. Also at the hearing is Crowe's probation officer, Natasha Hill.
Allegation made against you is that you were non-compliant with your probation. How do you want to resolve this matter?
I would like to extend my probation just because I did move downstate. I do have a job, so I'm trying to pay everything off. The reason why I have not been able to test is because it's $45 every time I test, and I owe the testing facilities almost $120. I'm not made of money. I do not have the money to test. But why am I being drug tested when there's no substance issue with my case whatsoever?
What kind of a store did you go into to steal from?
It was a sex shop, and I stole fuzzy handcuffs.
Says the Fantasy's smoke shop.
It was a sex store, Your Honor. The smoke shop is a porn store.
I wasn't the one who sentenced you. So all I can tell you is the judge did put it in place, and you've not been doing it. So,
Your Honor, I admit I smoke marijuana for my autism.
so what doctor prescribed marijuana for autism?
It's not prescribed, it's recreational. It's the only thing that helps.
How do you know that?
When I take 2 hits, I can finally feel normal.
Now, you can feel stoned is what you can feel.
Your Honor, it's not like that. It's recreational for me.
Do you understand what recreational means?
It's because I don't have a medical card. That's why it's recreational.
I've never heard of marijuana being used for autism.
It's $275 to go get a medical card. I don't have that kind of money.
Stop smoking marijuana, you'd have money to do your drug testing.
I'm not going to stop smoking. I'm sorry. Not going to happen.
Your
I
Honor,
have dropped-
with her attitude in court, I'd be willing to change my recommendation to 10 days jail and discharge her.
Why? I don't have an attitude. I'm down here working. I have a job. I have to go to work tomorrow.
You don't have
I
an
can't
attitude?
lose my job.
Oh, man. Want to know why the judge originally, on my view, said you had to be drug tested? Is because the only thing that you're fired up about in life is your marijuana.
No, it's not, Your Honor. That is a bull-faced lie.
Judge Hesselink appears to have run out of patience and tries to wrap things up.
So, Ms. Crowe, do you want to do all of your probation requirements, or do you want to do 10 days in jail and be done?
I will do all my probation requirements. I'm not going to jail.
I'm going to adjourn today's hearing for 3 months. You must do everything, or we're going to have a problem. You understand?
Yes, sir.
All right. Talk to you in 3 months.
Thank you.
3 months later, after Crowe failed to complete any of her probation requirements, the judge sentenced her to 10 days in jail. Next, we go to Allegan, Michigan for a traffic violation hearing. 30-year-old Savannah Jo Peak has been cited for improperly passing a school bus. A month earlier, police say Peak drove past a bus as it was picking up a group of school children with its stop sign extended and red lights flashing. The bus's camera recorded Peak's license plate, and a few days later, police issued her a citation. Today, Peak appears remotely before Magistrate Daniel Norbeck to contest the ticket. Also at the hearing is Richard Avery, the bus driver, and Deputy Alan Klein, the officer who issued the citation.
I was informed by Martin Public School bus driver Richard Avery that a red Dodge Journey had passed him on the same direction westbound on Wildwood near the intersection of Patterson. That vehicle is registered to Savannah Peak. We spoke about the incident. She admitted to passing the bus with the red lights on.
I never admitted to that.
Ma'am, this is not your turn. You'll have an opportunity to ask questions or testify on your own behalf later.
She stated that she passed the bus on red lights and that there was not a stop sign out.
Miss Peak, do you have any questions for the deputy at this time?
Yeah, why did he lie? Why is he lying? If he's an officer of the state, why is he lying? That's illegal. He should not be lying.
Ma'am, that's not a real question. I'm not going to have him answer that.
The magistrate moves on and hears from the bus driver next.
Mr. Avery, what is it you'd like to tell me?
I proceeded to the stop. I kicked my yellow student stop lights on before I got handed. Once I reached the driveway, I hit my red student stop lights, my red stop sign kicked out on the driver's side. It has a flashing light on the top. It has a flashing light on the bottom. I did certify that day that everything was working. The vehicle pulled up behind me with the high beams on, and they came up behind me, and before everybody was on, I'm talking, ma'am. You'll have your turn to ask me any questions that you like, and I will gladly respect your time.
Mr. Avery, please don't address Miss Peak directly. I will try to wrangle it a little bit for you, but Miss Peak, again, this is his turn to speak. You're going to have an opportunity to ask. Miss Peak, if you say one more thing, I'm just going to make a ruling, and this hearing's going to be over.
Avery finishes up his testimony.
So I pulled up, all my lights and flashers, my student stop sign was working, the kids were getting on the bus, and
The car blew by me.
Thank you. Ms. Peak, right now is your opportunity if you have any direct questions for him.
I want to know why people are lying on me. He did not have a stop sign out. And I did not run past him. I was probably going 10 miles an hour.
Ma'am. Okay, listen. So now the testimony against you is done. What is it you would like to tell me of why you should not be found responsible on this citation? Go ahead.
For one, I looked up the law. You need to have a stop sign and the red lights out. You need both. You have to have both. It's in the law book. I looked it up. I read it. I never ever once said, oh yeah, he had red lights on and I passed. I never said that. I said he did not have a red stop sign out, so I thought it was okay to pass. I came to a stop, I looked, I seen the kid get on the bus, I waited. He got on the bus, so I slowly went past him. I did not zoom past nobody. I will be getting a dash cam from now on.
When she's finished, the magistrate makes his ruling.
So after hearing all the evidence, I do find that you are responsible on this citation and that you clearly passed the bus when you are not allowed to. You do have a right.
Stop sign out or have his license revoked. He should not be driving a bus for picking up children.
That's not
He's not
true at all. I doubt I'm going to be able to get the word in here. All right. Thank you.
Peak was ordered to pay $200 in fines and court costs. Next, we go to Wyandotte, Michigan for a sentencing. 48-year-old Robert James Allen has pled guilty to operating a vehicle while visibly impaired. A year earlier, police say Allen was pulled over for defective license plate lights. Then, when he appeared intoxicated and failed to cooperate with officers, he was arrested and charged with DWI and disorderly conduct. He was released on $500 bond. Allen later took a deal from the state, where in exchange for pleading guilty to the reduced charge of driving while visibly impaired, the disorderly conduct charge would be dropped. Today, he appears before Judge Elizabeth DeSanto to hear his sentence. Allen is represented by attorney Mark Awada.
Mr. Allen would respectfully request the opportunity to withdraw his plea based on what I believe to be the perception of my ineffectiveness in representing him during the plea negotiations and his acceptance of the plea. He doesn't believe that I properly advised him.
Okay. Mr. Allen, you have been to court a number of times with Mr. Awada, correct?
Yes.
Okay. And so now here we are at the date of sentencing and you want to have a different attorney and you want to withdraw your plea.
I don't necessarily want a different attorney, but I want to withdraw my plea.
Okay, so
you're trying to put me on probation and that's not even part of the punishment.
Pause. Probation is something that courts impose in lieu of jail, sir. Now, if you don't agree to probation, that's your right. And the court also has the right then to impose jail, if that's what the court determines it's going to do.
I apologize, I'm not trying to be disrespectful, I just don't agree with the punishment for the crime, that's all. If you put me on probation, I feel like you're setting me up for failure.
And why is that?
I haven't seen my granddaughter, my goddaughter, or my kids in over 30 days. I'm stressed out, I'm sad, I'm depressed, I'm sorry.
And why can't you see them?
Because my license are suspended.
They can't come to see you?
My son don't have a car, you know what I'm saying?
What about a bicycle? What about somebody else?
I'm disabled, I'm gonna ride a bike from Detroit to Woodhaven.
Sir?
You're asking me, man, this is ridiculous, man.
I'm just asking options.
Can I just get a fine and go about my way, man?
First of all,
how could they even recommend
Stop interrupting me. Stop interrupting me. As of now, this is still scheduled for sentencing until this court receives a written motion regarding a plea withdrawn.
Okay. Thank you, Your Honor. I just wanted clarification. I'm sorry. I apologize.
Allen retained a new attorney, and his written request to withdraw his guilty plea was granted. His case is now pending.